The next case come before us is Stepka versus McCormack. Both sides ready to proceed?
Yes, Your Honor.
Yes, right.
All right, the appellant may have up to, well, have 15 minutes, up to 5 minutes for rebuttal.
Your Honor, I'd like to reserve 3 minutes for
That's
rebuttal.
fine. Thank you.
May it please the court, my name is, I'm sorry, you're ready, Your Honor.
No, I'm fine, you're fine.
May it please the court, my name is Colleen Mountcastle, and I'm here on behalf of the appellant, Thomas McCormack. Mr. McCormack was sued by Ronald Stepka in a legal malpractice matter. Mr. McCormack represented Mr. Stepka in a domestic relation proceeding in Lorain County, Ohio, based on a dismissal of the legal separation claim that Mr. McCormack brought on behalf of Mr. Stepka. The matter wound up being sent over to Minnesota based on Mrs. Stepka's immediate dismissal of a counterclaim for divorce and refiling in Minnesota. In our first assignment of error, we argued that the trial court erred in granting Stepka's motion for protective order and denying Mr. McCormack's motion to compel. The subject of those motions were the Minnesota Successor Council's file. Mr. McCormack was denied the ability to look at that file, and it was critical to his defense in this legal malpractice matter. Mr. Stepka at trial twice testified that the sole reason that he settled in Minnesota, voluntary settlements under terms that were agreed to by the parties, was under the advice of his Minnesota counsel. So it was important for Mr. McCormack to be able to look at that file and to know why decisions were made by Minnesota counsel, including the decision to take no action whatsoever to dispute jurisdiction in Minnesota or to make an effort to bring the case back to Ohio.
But how was the attorney-client privilege waived?
Your Honor, there's two arguments that we talk about. First is that there's an actual exception to the attorney-client privilege so that it never attached. And we're looking at the Squire Sanders case from the Ohio Supreme Court that talks about self-defense. At the outset, I will recognize, as the trial court did in its decision, that the self-defense exception to the attorney-client privilege is normally applied in situations where an attorney is sued by his former client and the attorney is asking to divulge information and communications directly between that former client and the attorney himself. In this instance, we're looking at successor counsel's file, which again is a little outside of the self-defense as it's been applied thus forth.
So you would be asking us to extend.
That's right, Your Honor. And I would suggest to you that the Jackson decision and the Squire Sanders decision out of the Ohio Supreme Court has not foregone the ability of common law exceptions. Squire Sanders sets out the 4 common law exceptions. The self-defense exception is one of those exceptions to the rule. And in that discussion, the Squire Sanders case, if you look at paragraphs 40 through 47 of the decision where it's talking about the self-defense exception, it talks about fairness and justice. And the reason for the attorney-client privilege in the first place is in the furtherance of justice. But when it is not just, it must yield to the practice of justice. And if there was ever a case where that would apply, it would be here, because it was successor counsel's advice to Mr. Stepka that ultimately led to the settlement terms, and it's those settlement terms that were agreed to in Minnesota that are being used against Mr. McCormack in Ohio to determine the damages here. And that's why it was critical to his defense. If I may move on to our third assignment of error, Your Honors, just for brevity's sake. In our third assignment of error, we argue that the trial court's verdict and decision should be reversed because the damages allegedly sustained by Mr. Stepka were not proximately caused by Mr. McCormack, and the damage award is entirely speculative. Speaking to the speculative nature of the damages first, the court in the body of the order that was rendered in this case, where he talks about the $300,500 award provided for compensatory damages actually talks about the domestic relations court using a rule of thumb, and that he was making his decision despite Ohio law, case law, and statutory law. So he's setting out there that I'm not suggesting the domestic relations court had to follow a formula. I'm not suggesting that this is a known damage. I'm just suggesting that this is what I think Judge Baczynski in Lorain County would have done had this matter been tried in Lorain County.
Well, wasn't there an attorney who testified as an expert on behalf of the appellee who gave some, perhaps, I don't know if it was nebulous, but some testimony about having practiced in that court, and this is kind of where the rule of thumb came from? Yes, Your Honor.
There was an expert that testified on behalf of Mr. Stepka. He also testified that he spends probably 5 to 10% of his time in Lorain County and had only been in front of Judge Baczynski probably a handful of times. That is in the record, where it's a fairly limited amount of time to suggest some very specific damage numbers in the judgment itself.
So that would go to the weight to be...
It would, Your Honor, but the judge in the trial court decision sort of mixes and matches things. He has his findings of fact and conclusions of law, and his conclusions of law actually speak to proximate cause. They speak to the amount of damages. He does reference it as well in the findings of fact, where he breaks it down for each particular category. But there's a couple concerns with that. We are still talking about a matter of law with respect to damages, because in a legal malpractice case, you have to show proximate cause. You have to show that you would have been successful. The case within the case, the environmental network versus Goodwin, Weiss, and Miller case, requires that. What happened here is, this is not a matter where you're comparing apples to apples, but it's apples to oranges, and there's actually an added layer. The case, or what the expert was arguing on behalf of Mr. Stepka is, this is what he would have gotten if he tried the case in Ohio in front of this particular domestic relations judge. But what actually happened was, he settled the case volunteering to the terms in Minnesota. So it wasn't a trial-to-trial situation. It wasn't a, in fact, there was no analysis of what he would have gotten in Minnesota whatsoever presented by that expert, I should point out. The expert says at page 176 of the transcript, I don't know Minnesota law. He says at 198 of the transcript, I did not perform analysis as to what he would have gotten under Minnesota law. What he performed was an analysis based on a voluntary agreement and settlement and those terms versus what he believes he may have gotten in Ohio had he tried the case. So it's a true apples to oranges comparison, and it adds to the speculative nature of the damages.
But you can, but you back up before you even get to the setup. You wouldn't be in Minnesota, perhaps, right?
And Your Honor, Mr. McCormack himself at trial recognized I shouldn't have dismissed the claim. He recognized that the dismissal of the claim is what allowed Mrs. Stepka to dismiss her divorce action and refile in Minnesota. However, it was a correctable error. There were actions that could have been taken, meaning oppose the jurisdiction in Minnesota. Mr. Stepka never lived in Minnesota. He had valid arguments that could have been made at the outset in Minnesota and would have allowed the case to come back here to Ohio. I'd like to also address our last two assignments of error that deal with the mental anguish amount that was awarded. The judge ordered $150,000 in favor of Mr. Stepka for mental anguish relating to the child custody. His wife gets the residential custody of the children under the terms of the settlement agreement in Minnesota. And the court first is basing that decision on speculation that had the matter been tried in Ohio in front of this particular domestic relations judge, Mr. Stepka would have gotten permanent custody. So you have the first, assumption being made But the second part of it is the $150,000 award. This is a legal malpractice claim. You must show that there was an intentional action, willful conduct, in order for there to be any sort of emotional damage claim to be awarded.
Well, was there testimony that, as to the way that the children, or at least one of the children, was taken, that, you know, there was some subterfuge there?
There was, Your Honor. There was a discussion of the child's maternal aunt came to get the children, told Mr. Stepka, hey, I'm just going to take the kids to play with my daughter or son, and ultimately gave the children to the mother.
Right. Couldn't that form the basis of that deliberate kind of, you know, mindset?
I think there's two problems with that, Your Honor. The first is that has nothing to do with Mr. McCormack's actions. He wasn't behind the scenes telling this aunt to do this in any way, shape, or form. And the second part of it is...
No, but we're talking about the damages.
I understand, but they have to be related somehow to Mr. McCormack's actions in order for them to be allowed under the legal malpractice standard. I just wanted to follow up. There also has to be something from Mr. Stepka saying, and that action wound up causing me to go to a psychiatrist. It wound up me having sleepless nights. There wasn't testimony as to what type of harm was done to Mr. Stepka in terms of those things before you can get to a mental anguish damage. The other part of it is, despite all of that, at Appendix 14, so we attached the court's order, so Appendix 14 is the page because it was an unnumbered decision. The court actually, in awarding the mental anguish, says due to defendant's negligence. So he was not basing it upon a willful or wanton or intentional act on the part of Mr. McCormack. He actually says in the order that he was basing that mental anguish award on negligence. It's not allowed in a legal malpractice claim. You have to show willful action on the part of the attorney.
So you're saying in no circumstances could you get an award for mental anguish in a legal malpractice, basically, like when your children are taken?
Well, it's also questionable whether you really could, because the Pyle versus Pyle decision that we cite to is talking about the nature of domestic proceedings in and of themselves. People are always going to be under emotional turmoil. It is something that is heart-wrenching for families when they're getting ripped apart, when there's finances and obvious, you know, very important factors coming into play, like your children moving to a different state. So it is questionable, even if they had met the willful, wanton, intentional action standard, whether it would have been appropriate for the court to award the damages for the mental anguish aspect.
And you're into your rebuttal time, but I just want to follow up, you know, Eric. It's one thing to be going through the mental just problems or, you know, anguish, whatever you want to call it, going through a divorce is another thing that you don't see your children on a daily basis. Isn't that a completely different type of feeling and mental anguish?
It is, Your Honor, but I still think that even if with that, you need to establish how did that affect you. I understand that it seems common sense, of course, that's going to hurt someone, and I didn't mean to roll my eyes, I meant it as, you know, you come to that conclusion regardless. The problem is you really, under the legal standard, have to establish what was the cause of that emotional, or what is the result of that emotional damage. Are you losing sleep? Are you going to see someone? You have to prove that in order to get an award.
So he didn't testify as a result of that, you know, I can't sleep at night, I'm losing time at work, or I'm, you know, despondent, or I'm depressed, or any of those things?
Nothing that concrete, Your Honor. Certainly said it was upsetting to him. I'm not going to suggest that he didn't, you know, say things along those nature, but there was nothing concrete, and there was certainly nothing that the court relied upon in making that decision either.
Okay.
Thank you.
Good morning, Your Honor. William Eady on behalf of Mr. Stepka. I'd like to start where we left off with, I think, some insightful questions about the question of emotional distress. If we accept the argument from Attorney McCormack, you can never have emotional damages as a result of legal malpractice. And that just doesn't make sense.
Well, would you point us to any cases anywhere in Ohio where damages were sustained for mental anguish in a malpractice case?
Yes, Your Honor, and specifically Kelly v. Buckley, that's out of the 8th District in 2011. And there's testimony that as a result of, in that case, it was sleepless night and worries. But I'd like to go back to the line of questioning about the difference between these types of damages. There's a difference between I'm upset because I had to go through a legal proceeding. I'm upset because things didn't go my way. Versus in the underlying case, the harm that was caused was not having your children, not having custody of your children. And we went from, as the court says in the factual findings, a custodial parent who was very dedicated to his children and saw them on a daily basis. Mr. Stepka was a firefighter, he had a flexible schedule, he was the primary caregiver, to his children being out of state and seeing his children for a limited basis 3 times a year. So that's the underlying case, that the malpractice caused Mr. Stepka to lose custody of his children, and the harm that flows from that, understandably, is primarily emotional, not economic. It's very similar in the medical malpractice context, where your harm may be both economic. Say a doctor operates on the wrong leg and you lose your leg. The direct harm may be you can't perform certain jobs, you have economic harms, you have additional surgeries, you have therapy you need. But there's also the underlying emotional harm of the fact that you've lost your leg. Not a separate claim for emotional distress that I'm angry that I had to go through this process and that the emotional impact of just losing a case. And that's the distinction I think McCormack fails to make in this case. The difference between all the cases they point to relate to, I didn't want to go through this case. I shouldn't have had to go through this case. I'm upset because the jury didn't go my way, versus, for example, some of their cases involve bankruptcy proceedings. My lawyer failed to make a claim in a bankruptcy proceeding, so my economic interests weren't protected. I'm very upset by that. Well, that's a situation where you might plead a separate case for infliction of emotional distress. This is a case where the actual underlying case itself involved damages, in this case, loss of custody of a child.
So you're almost arguing a presumption of mental anguish.
Well, I would like to think we live in a world where losing custody of your children would be presumptively emotionally harming. I don't know that that's the case. It doesn't need to be the case. The court was there to hear the testimony of Mr. Stepka.
So what was the testimony?
The testimony was that he was very connected to his children, and specifically the factual findings that the court made on this point, I think, are very important. Mr. Stepka was the primary caregiver to his minor children. He had an extremely close bond with his children. He suffered mental anguish and a loss associated with the limitation of time that he can spend with his daughters, resulting in permanent interruption of his relationship with his children. So the judge who was there witnessing the testimony by Mr. Stepka saw and observed the closeness of this bond with his children and the apparent on the stand emotional anguish even talking about the fact that he wasn't going to be a custodial parent to his children anymore. So in some cases where maybe you've lost money or there's other things that are a little less immediate to the emotional state, it would make sense to say, oh, where's the testimony of a sleepless night? Where's the testimony that this economic harm really did affect you emotionally deeply in the context of a separate emotional distress claim? That's not where we are in this case. Where we are is the underlying case was a domestic case that involved custody strictly because of Mr. McCormack's flagrant negligence. I mean, he admitted it was a terrible mistake to dismiss the underlying case and not bother refiling it in Ohio, among other failures that the court found. That's a true harm to lose your children, and the testimony and the factual conclusions we have to defer to from the trial court was that it was a severe emotional distress because of that relationship.
So your position is that we don't need to find that the action on behalf of Mr. McCormack was willful that negligence suffices? Is that the position that you take?
I would suggest that two responses if I may. One, there is a difference between the willfulness standard that needs to be brought in a case where you're alleging a separate claim of emotional distress arising out of the process of the legal malpractice. I'm upset that I sat here in court and when you told the judge that I didn't need a jury, I'm upset because I lost the case. That's different than an underlying harm in the case, like a surgeon operates on the wrong leg. You don't plead a separate case of emotional distress against a surgeon. The professional negligence, which the Ohio Supreme Court likens the attorney professional negligence to medical negligence, the mere fact of the negligence itself and the loss of a leg leads to emotional damages without any heightened standard.
It flows from that.
It flows from the direct, well, exactly, but I wanted to, it's a fine distinction that I think is lost in the paperwork in this case. There is, I'm sure, harm that can flow from malpractice tangential to the underlying case. I'm sure people really are upset sometimes when they sit through a court proceeding and lose the case, separate from what their claims are in the underlying case.
This kind of reminds me of the wrongful death, and I was asking a little bit about the presumption. Of course, there's a statute there, but just by the nature of being what the legislature considers a close enough relative, you're going to have presumed damages for the loss of your loved one. Now, the argument is obviously in some of the cases that are that's made, what about other types of harm, and do you have to prove them separately? And that doesn't directly flow from just the loss itself. Like anybody that's, like maybe a sister, let's say, and you lose your sister, then it's presumed that you suffer mental anguish as a result of that. Now, the argument may be you might be able to suffer different mental anguish based on the circumstances of that death. That would be a different.
And I think that's a great point. So in the underlying wrongful death context, or a loss of consortium claim in the medical malpractice for a spouse, or the direct economic harm to yourself for medical malpractice, the emotional harm to yourself for medical malpractice, there's the underlying claim that directly flows, those emotional damages flow from that underlying harm. Where should Mr. Stepka have been in this underlying case? He should have had custody of his kids. And he didn't, because the reason that was taken from him is because of the negligence, versus what I think we're driving at is the separate issue of, I'm upset because you committed malpractice, doesn't matter what the underlying claim is. It could be a breach of contract case. I'm up at night because I didn't get that money I thought I was entitled to under this contract. That's where you plead a separate case for intentional infliction or negligent infliction of emotional distress, because you wouldn't have had any claim under a breach of contract case to emotional damages, or even the presumption of any harm, or even, really, I think that's why we have the heightened standard. It's hard for us to believe you do suffer that real emotional harm over relatively trivial issues like money, as opposed to custody of your children.
Can you speak briefly to the issue of causation?
Yes, and I think the problem with McCormack's argument on the issue of causation, I'd say that covers a number of the assignments of error. They all basically relate to, you just can never prove what a court would have done. You can't prove what would have happened in Minnesota. You can't prove, we would not have legal malpractice cases if you could not put on competent, credible evidence such that a fact finder, who in this case happened to be a judge, could find it's more likely than not the outcome without the malpractice would have been X. Let's compare that to where you ended up and determine your damages. And here, the actual evidence that the judge relied on, beyond just the rule of thumb that opposing counsel brought up, which, by the way, only relates to the division of the marital assets, not to the underlying question of custody and things like that. We also had testimony from the guardian ad litem, Mr. DeRay, who testified that he's done probably 300 to 400 cases in Lorain County. He's very familiar with the judge at issue. He testified that this judge, like the other judges, would not be in favor of relocation of the children. So remember, the children start in Ohio. They leave Ohio because of the malpractice in failing to request an emergency restraining order to keep the children local. So we had Mr. DeRay's testimony that any of the judges, including this judge, would have said, you are not taking these children out of my jurisdiction during the pendency of a divorce. We also had the testimony of McCormack's own expert, and to the question about whether there is some expertise on Minnesota law. Their expert, Nancy Berg, is a Minnesota attorney. She admitted, among other things, that there would have been no Social Security offset in Ohio, as there would be under Minnesota law. That's her transcript at page 32, that not counting Ms. Stepka's Social Security contributions was a detriment to, under Minnesota law. Counting Mr. Stepka's inherited property as marital assets was another disadvantageous position under Minnesota law. There would be no income equalization. Minnesota law provides the length of the time a child has lived in a satisfactory relationship work to Mrs. Stepka's advantage. Because by that time, due to Mr. McCormack, Attorney McCormack's negligence, the children have been living in Minnesota for almost a year. So their own expert says Minnesota's a bad place to be compared with Ohio if you're Mr. Stepka. And she actually goes on to say that he's additionally disadvantaged by failing to refile the Ohio case immediately in order to challenge Minnesota jurisdiction. Failing to keep the children in Ohio, which, quote, would have put, she's referring to Mr. Stepka here, in a more advantageous position as part of the litigation versus going to Minnesota. Failing to ensure that children stayed in Ohio for the duration of the case, which would have put him in a better position to maintain custody, and dismissing the Ohio case, which prevented Mr. Stepka from presenting his case in Ohio. That's all their experts' testimony, that Mr. Stepka was worse off in Minnesota. And I'd like to touch briefly on the apples to oranges question, because as to a settlement in Minnesota versus a presumed trial in Ohio. What
I was going to ask you something.
What that really relates to is a failure to mitigate argument. Now they're using it in the context of, oh gee, these are speculative damages. These are speculative damages. In fact, the standard there is just, is there competent, credible evidence in the record to support the judge's conclusion? I just rattled off their own expert's testimony that the judge could rely on. So I think we've satisfied that. But the real issue they're missing is that a failure to mitigate an affirmative defense is their burden. So we know because of this negligence, the court found here's how you've been, here's where you were able to end up. That's the settlement agreement. Okay? If my roof starts leaking and I spend a bunch of money to fix my roof, I've mitigated my damages. Mr. Stepka was forced to Minnesota. His children were taken to Minnesota, all flowing from the negligence in this case. And he did the best he could to mitigate his damages. He acted reasonably. And he acted reasonably because he relied on another attorney. I mean, the mere fact that relying on an attorney's advice in a legal proceeding means, at least with respect to Mr. Stepka, he was being reasonable. He didn't try to do this on his own. He wasn't making his own decisions.
Well, that becomes somewhat of a circular argument as to the discovery of which you probably won't have time to talk about, but whether or not the successor attorney's files should have been available.
I think there's one critical point on that that I can squeeze in, and that is that the papers were available. All of the papers were available, including the consent decree. The only thing that wasn't available was attorney-to-client direct communications. And nowhere in the court record below, nowhere in argument, and not today, have we heard any evidence of anything that would be vital to the defense. So where we are is there's a statutory defense. There's no waiver, no involuntary waiver or implied waiver under a statutory defense. They lose that argument. Even when we accept the argument that there could have been an implied waiver, which there wasn't, that's the Hearn test that this court doesn't accept and the Supreme Court rejected, you'd still have to show there was something missing that was vital to your defense. And what the court found was, you haven't shown anything that could be vital. How could it matter why or what the arguments were about where you ended up, when what matters is, where did you end up? And if they want to really make a failure to mitigate argument, which is essentially what they're making, then what they have to do is show, affirmatively, that the result was unreasonable. So in the roof repair case, instead of calling a repair person, if I let it drip for 3 months until the floor collapses under the weight of the water, well, the roofing guy I sue for the leak is going to say, well, you weren't reasonable in mitigating your damages. Here, there's no testimony about that. Their own experts said he's disadvantaged under Minnesota law. Settlement was the best choice, but importantly, Mr. Stepka didn't have to prove that settlement was the best choice. It's not his burden. They have to prove not only that it wasn't his best choice, but that it was an unreasonable decision. And they haven't done that. It wasn't an unreasonable decision. He was put in a bad position because of Attorney McCormack. His roof started leaking because of Attorney McCormack. He took the steps he could to fix that and got the best he could out of that. And they presented no evidence that that was unreasonable, nor I would suggest would confidential attorney-client communications change that analysis. Thank you.
Very quickly, Your Honor, on the point that Nancy Berg, the expert that testified on behalf of Mr. McCormack, to suggest that she said that he would have been better off in Ohio than Minnesota is simply not the case. There was a discussion, line by line discussion of the various things where he would have been okay here. Here are some places where it would have been to his detriment. Ultimately, she talked about how under Minnesota law, Mrs. Stepka actually took on more of the liabilities, which related to an offset, and she certainly did not suggest that Mr. Stepka would have been disadvantaged to the tune of $300,500 as the trial court found here. I think it's interesting also that there was nothing discussed in terms of that number other than pulling it out of the air and saying this is the rule of thumb that the judge would have followed in domestic relations court. That is the number that was not proven, the $300,500 amount. Stephen DeRay only talked about the child custody issues. He said there were several factors that went into his decision, and it wasn't just merely that the kids were located in Minnesota. He certainly found some points where they had certain things activities they had gotten involved in, but he said it was an entire circumstance, all the circumstances he looked at, not simply that they were there during the duration of the divorce proceedings.
And you need to wrap up.
Yes, Your Honor. I would just conclude by saying the trial court's decisions denying McCormack's motion to compel and granting the motion for a protective order should be reversed. I didn't get to address it, but the court's denial of the motion for summary disposition should also be reversed. And ultimately, the trial court's decision from the bench trial, the verdict in favor of Mr. Stepka should be reversed. Thank you.
Thank you both for your presentations to the court. The court will take it under advisement, send you written opinions as well, and you can look on our website. Thanks.